unveiled the government's plan for improving the lives of every Guyanese. In his address, His Excellency stated that, and I quote, "Justice is at the center of all democratic governance. Justice that is predictable, fair, accessible, and equitable to every citizen." This declaration shows not only dedication to the principles of good governance, but also the government's broader vision for national development and understanding of the fundamental role of updated laws and law reporting in achieving that development. As we have heard from the Honorable Attorney General, under His Excellency's vision and passionate leadership, the realization of this project was made possible through significant state investment and a clear dedication by the government of Guyana to strengthening and modernizing our legal framework and institutions. Ladies and gentlemen, please join me in welcoming His Excellency President Dr. Mohammed Irfan Ali to deliver the feature address. Your Excellency.
Thank you very much. Thank you, please. Thank you. Our dear Prime Minister, our Chancellor, members of the Cabinet, our DPP, members of the diplomatic community, members of the judiciary, members of the legal family, retired justices, and all functionary within our legal ecosystem in Guyana. Today is an important day in your lives, as it is an important day in the life of our country. Before I proceed, allow me to congratulate the Attorney General and his entire team, Professor Newton and her team, and all the stakeholders who were part of this enormous exercise that brings us here together today, and I ask you to put your hands together for all of them. In my own view, the law is meant to be practiced. The law is something that is alive. The law is a living entity. And if we are to practice something that is alive, then we have to ensure that we understand the environment in which this entity must be practiced. Therefore, in my humble view, the laws of Guyana is part of a much larger infrastructure. It is part of the international frame. And it is in this context that I believe the revision of laws will be a normative process in our life moving forward. And I'll tell you why. But before I do so, it is important for us to appreciate that the laws allow us to have intellectual reasoning in our decision making and our judgments. It allows us to have soundness in the legal precedents. And I coined a concept of precedent proof for past and future, because our decisions must also pass a basic test to be precedents for the future. It is important also that we acknowledge the fact that our laws, though locally focused, exist in a global framework. Therefore, the laws must be applicable and adaptable and practical in the world in which we live. And the Attorney General rightfully outlined the historical context as it relates to the development of our laws. If we look at the development of law itself in the global frame, we had first the movement away from subjective retribution to fixed penalties, the Code of Urnamo. Then we went to Greek law, which was citizen-based, establishing legal structures. However, it excluded women and slaves. Then we went to Roman law, which brought into existence professional jurists, a concept that introduced the presumption of innocence. Then we went to the common law, which spoke of judicial precedence, and the traveling court, which is about accessibility to justice. Civil law, which brought the heavy modernization and codified existence of laws, and then the rule of law, limiting the monarch's power. And the rule of law is an important concept for us in this region and for the global community. And then when you look at the factors that influence the development of law itself, we have the first set of laws influenced heavily by religion. Then we had the enlightened rules, which spoke of natural rights, social contracts. Then trade and property, which spoke about predictability, system-based, and rule-based. And there's a reason I'm highlighting this evolution to you. But today we are faced with many different challenges in the applicability of law and the development of law itself, and the functioning of our judicial system in this new environment. And in all of the challenge that we face globally, I can say without a shadow of a doubt that our judiciary, the legal systems supporting our judiciary, whether it's the DPP, the police, and the executive, we are all making the investments that will allow us to meet these challenges successfully. The first challenge is technology and digitization. The first thing I ask the AG is whether an ordinary person can put a particular code in, and the website or the platform will be able to give them that piece of legislation or that law that is applicable to what they're seeking. And he said to me that's the next phase of the development. Because the days of searchable websites are long gone, unfortunately. The websites now must be interactive, must be able to have an interactive platform through which people access information with a deep AI backbone. That is no longer a luxury. No longer a luxury, but part of a revolutionized system that will allow us to address the emerging issues of technology and digitization. The second challenge facing us with predictability, system-based, and the rule of law is political polarization and dysfunctional legislators. another real challenge that we are faced with. That our laws must take into consideration. Globalization and transnational issues, the declining public trust and rule of law erosion, accessibility to justice, and clearing up backlogs. We know the Chancellor and the judiciary have a special project in which they're dealing with backlogs. Ineffective implementation. Lawyers must be people who love to read. Read consistently. A lawyer who is unaware of current issues is a lawyer that is unprepared. Fortunately or unfortunately, you chose a profession in which continuous learning, reading, is not a luxury. It is part of your daily lives. That is why sometimes we say the life might be boring, right, Chancellor? But it is. It is your choice. It is your choice. That is why lawyers should make good practitioners in public policy, because they should be well read. They should be well connected with the realities of the world. I'm not saying we're disconnected, but sometimes I search for the connection when I see some presentation. Lawyers and laws must be relevant to the development trends, shift, and functionality of the economy and where we are going. It must be able to deal with, we have our legal counsel from CARICOM here, and she will tell you we are now embarking on a project to have someone review the laws to deal with our criminal justice system throughout the region. Because we are talking about a common approach to transnational crime, regional crime, and crime fighting, and there is a differentiated benchmark through which we are developing a common approach. That is why I'm very happy that we have this regional integration in this whole process here today. I say this to say that what I would like the AG to do is to have a presentation with all of society, the private sector, and everyone who is affected and part of this process, in which we clearly outline how the laws, how the new version, how it is linked to everyday life, how it addresses these issues and challenges, how it addresses some of the things that we are going to be doing as a government, as a country, moving to digitization, moving to electronic form of governance. Already, the Chancellor will tell you the teething problem when we started the e-ticketing. When we started the e-ticketing, the smart cameras, we know very clearly where we are heading. And we have to demonstrate how the laws would allow us, in a predictable way, to arrive at this position. So it is in that context that I wish to turn to my more structured remarks. Right, AG? I want to begin, yes, Chancellor, with a simple but enduring truth. A society without laws cannot endure. Without rules to restrain power, authority becomes unchecked. I don't think any individual can wheelbarrow coins in the AG office in the United States or anywhere else. And we have to deal with people who believe that they have this God-given right to abuse access and abuse system. I don't believe that can be tried anywhere else. And I've called up a few places. A society without laws cannot endure. Without rules to restrain power, authority becomes unchecked. Without legal protections, the weak are left exposed. In such a condition, order collapses, justice disappears, and society descends into chaos. And we have seen this. We have seen around us, in our neighborhood, societies would have descended into chaos. And unfortunately, we live in a global place. When societies descend into chaos, it explodes over borders. It explodes throughout regions. It creates conflict. It creates pressures on the other economies. It creates conditions that does not help to advance development and people. And that is why sometimes we need to understand the deep and far-reaching effect of laws. Without law, there is no order. Without order, there is only chaos. It is for this reason that Guyana stands and must always stand as a law-based society. It must remain a nation governed not by whim, not by impulse, but by rules that are known, applied, and respected. To be a law-based society is to embrace a system in which power is never absolute and authority is never arbitrary. It is a society in which no individual, no matter how powerful, is above the law. It is a society in which the rights of the ordinary citizen do not depend on favor, but are secured by principle and backed by the force of law. Laws are the foundation of a just society because they establish the rules that govern conduct, restrain power, and protect rights. They create order out of uncertainty and ensure that fairness is not left to discretion. When laws are clear and applied equally, and enforced consistently, they provide a structure within which justice can be delivered. Without that foundation, rights become fragile, power becomes unchecked, and justice becomes uncertain. In this regard, the rule of law must therefore be more than a phrase. It must be the very foundation upon which we govern. The rule of law demands more than the mere existence of laws. It requires that laws are clear so they can be understood. It requires that laws are public so they can be known. It insists that laws are applied equally so that justice is fair. And it compels that laws are enforced consistently so that confidence and public trust are maintained. A law that cannot be found has no practical value. A law that is outdated cannot be relied upon. A law that is applied differently, depending on who you are, undermines justice itself. A hidden law is no law. An outdated law is an unreliable law. An inconsistently applied law is an unjust law. It is against this backdrop that we gathered here today for an occasion of profound national importance. the launch of the revised laws of Guyana and the Guyana law reports. On that note, I also want to recognize former President Donald Ramatara. For decades, our laws have evolved, been amended, expanded, and refined. Yet when these changes remain scattered across time, buried in separate documents, and difficult to access, the legal system is placed under strain. Lawyers face difficulty in presenting arguments with certainty. Judges must work harder to arrive at confident decisions. Citizens are left unclear about their rights and obligations. In such circumstances, the effective functioning of the legal system becomes compromised. This is why the process of consolidation and updating of our laws is essential. Although AG, in some matters of great national importance, I saw some lawyers deliberately reading from laws that are no longer in existence. Yes, that's true. Chancellor, it is the current nature of the judge's ability to know which are the relevant from the irrelevant that allow justice to remain on a stable platform. The revised laws of Guyana represent the careful and deliberate integration of all amendments, all changes, and all new enactments into a single coherent body of law. When laws are consolidated, confusion is reduced. When confusion is reduced, disputes are minimized. When disputes are minimized, justice is strengthened. But laws does not live in statutes alone. It lives in the decision of our courts. It is through judicial reasoning that laws are interpreted, applied, and given life. When judicial decisions are not properly recorded, organized, and published, the legal system loses an essential source of guidance. Consistency becomes difficult to achieve. The development of legal principles becomes uneven. The reasoning that shapes our jurisprudence risks being lost. This is where the Guyana law reports assume their critical importance. Law reports capture the thinking of our judges. Yes, it captures the thinking of our judges. They preserve the principles established in our courtrooms. They provide authoritative guidance for future cases and ensure that similar cases are treated in a similar manner. A judgment unrecorded is a lesson lost. A lesson lost is justice weakened. The doctrine of precedent, the very backbone of our legal system, depends on the availability of these decisions. Without law reports, precedence becomes uncertain. And when precedent is uncertain, justice becomes unpredictable. Guyana's legal system has long enjoyed a reputation for excellence. Our judgments have been cited in other jurisdictions, and our legal reasoning has influenced decisions beyond our shores. We must protect this level of trust that was built by great lawyers and practitioners of the law in our country. We must not allow a few to damage this reputation. We must not allow a few to damage this intellectual property that great members of the legal family fought for and positioned Guyana in. And Professor Newton, you cited some of those. It is important that we retain and strengthen that prominence. This requires ensuring wider and more timely access to our judicial decisions. Reducing the gap between when decisions are made and when they are published is essential. The publication of the Guyana law reports is therefore a decisive and necessary step in that direction. Taken together with the revision and consolidation of our laws, the publication of our law reports forms part of a broader effort to strengthen the very foundation upon which justice rests. It does this by ensuring that both the law as written and the law as interpreted are coherent, authoritative, and accessible. The publication of the updated laws of Guyana and the Guyana law reports significantly improves access to justice. Access to justice is not achieved simply by the existence of courts, judges, and lawyers. It is achieved when justice is understood, reachable, and usable by the people. Access to justice begins with the access to the law itself. When citizens cannot find the law, they cannot follow it. When they cannot understand the law, they cannot assert their rights. Access to law is access to justice. Knowledge of rights is the first step in claiming them. The consolidation of our laws into centralized, updated volumes removes one of the greatest barriers to justice: uncertainty. The availability of these laws in digital formats transforms access even further. And now, AG, we have to have them in searchable formats. Legal knowledge should not be confined to a few, nor should geography determine who can access the law. With digital access, a student can study the law from anywhere. A lawyer can prepare more efficiently. A citizen can understand their rights instantly. Justice must not be locked in libraries and chambers. It must be available at our fingertips. That is why today's event is so important. And I've said to the Attorney General already that the aspect of justice can only be appreciated if we have a comprehensive education program for the population. And whilst the workload on the AG chambers is heavy, we have to develop that mechanism through which education in justice and rights and knowledge in justice and rights for the citizens form an important and critical part of the work of the Minister of Justice and Legal Affairs. Legal knowledge should not be confined to a few, nor should geography determine who can access the law. Justice cannot be locked away. As we look to the future, it is obvious that periodic updating of our laws is no longer sufficient in a fast-changing society. The law must keep a pace with change. This is why new laws are passed or amendments made to existing laws. In this regard, a modern economy demands a modern legal system. A modern legal system, in turn, demands real-time relevance. One of the things that we definitely would have to address, and this has to do with my initial comment, the law as it relates to trade and property. Whilst a lot of our investments and investors are now coming from this hemisphere, a lot of, for example, US investments and investors, and our law heavily based on a British system, the arbitration component of the laws, and where it is governed, AG, we have seen this. More and more, these are becoming critical points of negotiations in agreements, critical points of negotiations in MOUs. And we have to address this. Guyana is in a different frame of development because of what is taking place here, where the investments are coming from. Therefore, it is important that we start to analyze these differences and come up with a framework that is applicable and relevant to our development, to our investment portfolio. And this is not speaking in abstract. We're seeing this from investors, whether from the US, from the UK, from the Middle East. The portfolio, or investors and investment portfolio, is changing. And the laws governing their operation are somewhat different. So these are the new challenges that Guyana would have to pilot as we move forward, because we have to address them. As soon as a law is passed and assented to, it should be reflected, at least digitally, in the body of our laws. Delays in updating create uncertainty. That is why a mechanism of update must be in place. We must create a mechanism through which updating the law occurs. It cannot be only projectized. A projectize is a temporary endeavor for a more permanent solution. So part of this permanent solution must be the mechanism through which we deal with future updates and amendments. This is especially critical in the context of Guyana's economic transformation. As our nation grows, as investment flows, and as opportunities expand, the importance of a strong legal framework becomes even more pronounced. Investment thrives in an environment of clarity, predictability, and fairness. It depends on a legal system that is modern, transparent, and reliable. Investors do not invest in uncertainty. They invest in clarity. They invest in predictability. They invest in the rule of law. Confidence in the economy begins with confidence in the law. Today's launch is therefore more than the unveiling of volumes. It is a reaffirmation of our national identity. It declares that in Guyana, the law will be known, the law will be current, and the law will be accessible. It declares that justice will not depend on privilege, but on principle. Let us also recognize those who have made this achievement possible. The process of revising laws and compiling law reports is painstaking. It requires precision, discipline, and unwavering commitment. The value of this work is measured in every case decided with clarity, in every right protected with certainty, and in every citizen empowered by knowledge. You have not merely organized laws, you have strengthened the rule of law itself. I thank all who were involved in this massive undertaking once again, especially our Attorney General and his diligent staff. This must not be seen as a final achievement, but as the beginning of a new standard. We must build a legal system that evolves as our society evolves. We must ensure that the law is always within reach of those it is meant to serve. Therefore, let the law be our compass. Let justice be our destination. Let Guyana stand as a nation where the rule of law is not merely proclaimed, but practiced, protected, and preserved. I thank you, and God bless all of you.
Thank you, Joanne, for those very generous remarks. I want to take advantage of the protocols so elaborately and elegantly established by our chairperson, but it behoves me to recognize, of course, His Excellency, Dr. Mohammed Irfan Ali, President of the Cooperative Republic of Guyana, Prime Minister, Brigadier Mark Phillips, Honorable Chancellor of the Judiciary, the Speaker of the National Assembly is out of the jurisdiction, my cabinet colleagues, former President Dr. Kamadana Ramatar, Director of Public Prosecutions, Chief Justice Navendra Singh, judges of the Court of Appeal, judges of the High Court, members of the diplomatic community, ladies and gentlemen, I have a prepared speech which is not normal. And I choose to prepare a speech because I want to share some very important historical facts in relation to law reports and law revision in Guyana. The launch of the revised laws of Guyana as of December 31st, 2022, and the law reports of Guyana 2008 to 2021 comes at a pivotal time when our country is experiencing exponential growth and transformation. In commenting on Guyana's economic climate, the International Monetary Fund, IMF, in 2025 noted, and I quote, "The economic outlook remains highly favorable. The economy is expected to grow at an average of 14% per year over the next 5 years, driven by robust oil production and strong non-oil GDP growth. Positive spillovers from the oil sector and improvements in infrastructure, productivity and reliance are expected to boost the real non-oil GDP growth to an average of 6.75%, unquote. Guyana's statutory framework forms one of the foundational pillars upon which this growth and transformation are taking place. Whether it is in the financial or commercial sector, the infrastructural realm, natural resources, public health, or agriculture, a robust and modern legislative framework is required to govern the particular undertaking. Professor Crabb, in his book Legislative Drafting, made the following seminal observations, and I quote, "Legislation is the framework by which governments achieve their purposes. To politicians and administrators, legislation is a means to attain their economic, cultural, political, and social policies. By legislation, policies are transformed into enforceable laws," unquote. It is by these very laws also that politicians and administrators are held accountable to the citizenry, and the citizens' rights and freedoms are guaranteed and protected. By Article 65 of our supreme law, the Constitution, our Parliament's wide and sovereign lawmaking power is subject to only two restrictions. One, to enact laws that are consistent with and intra vires the Constitution, and secondly, laws that are for the peace, order, and good government of Guyana. These laws are ultimately enacted by the elected representatives of the people for the people's benefit, and therefore must align with their values, aspirations, and ethos. From the beginning of time, and with it man's entry into society, his primordial quest has been for justice. The ultimate object of any system of laws is to deliver justice in accordance with law. According to the United Nations, I quote, "Access to justice is a basic principle of the rule of law. In the absence of access to justice, people are unable to have their voice heard, exercise their rights, challenge discrimination, or hold decision makers accountable," unquote. The operation of the rule of law is indispensable to any democratic society. The rule of law is the foundation upon which the edifice of civil society is constructed. Without it, there can be no economic progress, no social advancement, and no democratic governance. In short, no orderly society itself can exist in the absence of the rule of law. Therefore, easy access to an updated and consolidated compendium of the laws of any nation is the sine qua non for access to justice, the rule of law, and indeed peace, order, and good government. These concepts are the bedrock of the social and economic well-being of a strong and vibrant society. They aggregate to form that critical part of the architecture of any nation that inspires confidence in the economy and attracts investments, both foreign and local. This exercise of the revision and consolidation of the laws of Guyana is enkindled by the attainment of all these noble national objectives. The rule of law, its application and enforcement, and the consent of the citizens whom the laws are expected to govern will all become elusive unless the laws are regularly reviewed, reformed, published, and made easily accessible. Components of the project. This launch is the culmination of a project that will allow easy access to two primary sources of law: statute law, that is legislation enacted by Parliament, and secondly, judge-made law, that is law made by judicial decisions interpreting and applying the laws enacted by Parliament. The law revision component of the project involved the consolidation as well as the revision of all current legislation. This is a process of combining the legislative provisions on a single topic into one coherent enactment. Repealed provisions are removed and replaced with new ones, and principal acts are reorganized to accommodate the new amendments. This process also includes the changing of language of enactments so as to bring them in line with current usage without making any change to the substance of the enactments, as well as incorporating into principal acts new or amended subsidiary legislation, for example, regulations, orders, bylaws, etc. The importance of law revision was underscored in British Guyana as long ago as 1890 by the then Attorney General of the colony, Sir John Worrell Carrington. Writing in an article titled Statute Law Revision, the Attorney General posited, and I quote, "The conditions of its statute laws must always be a matter of very great interest and importance to any political community. It is clearly to the advantage of the state that its individual members should be well acquainted with the laws by which they are governed and whose operations affects to a greater or lesser extent their conduct and business and their relations with one another. We may go further and say that an obligation rests on the state to present to its individual members the body of public laws in a form so convenient, so well arranged, and so accessible that they can readily make themselves acquainted with its provisions," unquote. 135 years later, those sentiments have lost neither their relevance nor their efficacy, and I proudly associate myself with them. Historical overview of law revision in Guyana. As recorded by Dr. Mohammed Shahabuddin, another former Attorney General, in his work, The Legal System of Guyana, 1973, the history of law revision in Guyana comprised both private and public endeavors. From 1803, the laws of Demerara and Essequibo were regularly printed and published. The laws of Berbice were still in manuscript, and a party wishing to obtain a copy had to pay for it. Direct access to the originals was not permitted. In 1818, the British government had occasion to direct the governor of Berbice to transmit copies of all laws and other public acts passed and sanctioned in that colony. An official revised edition of the laws of the colony was for the first time authorized in 1815, after reference was made to the fact that the laws were scattered, unpublished, and largely untranslated. A committee of the Court of Policy of Demerara and Essequibo was established for compiling and translating all permanent value and to prepare an index, all of which were to be printed and published in one or more volumes. Nothing, unfortunately, came of this, and it is possible that the failure of the project led to the commercial publication of a document known as the Local Guide in 1815. Abstracts of the laws of Demerara and Essequibo, arranged rather unsystematically, appeared in the local guides of Demerara and Essequibo annually for the years 1815 up to 1822. Portions of the laws were also set out in the Almanac and Register issued in Demerara in 1821, 1823, 1825, and 1828. An official edition was authorized in 1838 when the Combined Court of Policy allocated funds and assembled a team to produce this edition. Unfortunately, it was never completed. The unsystematic arrangement of the laws of the United Colony of British Guyana continued and were produced in local guides of British Guyana for the years 1832, 1843, 1863, and 1864. In 1864, H.A. Firth, the immigration agent of the colony, produced a comprehensive edition of the laws of British Guyana, systematically arranged under subject matter headings. In 1870, he produced a supplement. Between 1870 and 1882, Lawrence McDormand, the publisher of The Colonist, the colony's only newspaper, produced an edition of the laws in 6 volumes with a separate volume containing an index for the period 1850 to 1880. In addition to these compilations, on the 1st of April 1864, David Arrott, a businessman in Georgetown, brought out a tabular index, alphabetically arranged, to the laws and ordinances of British Guyana as in force, either in whole or in part. It was not until 1895 that the first authorized edition of the laws was issued by Attorney General Carrington. This covered the years 1774 to 1895. This edition was, however, followed by a period of considerable legislative activity and apparently suffered defects inevitable in a pioneering venture. In consequence, it had to be replaced soon after by another edition issued in 1905 by Sir Crossley Rayner, Chief Justice of the colony. This covered the period 1774 to 1905. The 1916 transition to English common law led to a motion proposed by E.G. Wolford, a distinguished King Counsel in the Court of Policy in 1918, for a new edition. In 1923, a new edition for the period 1803 to 1921 was made by St. Clair Mackenzie under the supervision of the then Attorney General, Sir Joseph John Noonan, K.C. In 1930, a new edition was made by retired Chief Justice of the colony, Sir Charles Major. This endured for over 20 years, after which a further edition was brought out by Sir Donald Kingdon in 1954. The last revision of the colonial era was the 1953 edition of the Laws of British Guyana, which contained 11 volumes, including an index. And you heard Joanne refer to it as the Kingdon edition, as it was done under the hand of King Dunn, who was Attorney General of the colony at that time. Post-independence law revision of Guyana. Attorney General and Minister of State, Sir Sridat Surendranath Ramphal, in 1972, at the second reading of the Law Revision Bill, recounted the law revision exercises post-independence. After independence and until the law revision exercise in the 1970s, 2 volumes of the laws were produced annually. 1 volume of ordinances and acts and 1 volume of subsidiary legislation. The books became large and cumbersome to use. They cluttered the statute book from time to time with repealed legislation. As a result, there was a need for systematic law revision. In 1973, a revised edition of the laws of Guyana was completed, the first edition of the Green Volumes. This edition broke new ground as a new edition was produced in loose leaf form. The initial publication of this edition presented the laws of Guyana as in force on the 23rd of February 1970. However, miscellaneous amendments made to a number of laws by the Law Revision Act of 1972 were incorporated into this edition. From 1972 to 1977, law revision exercises were completed, which culminated in a newly revised edition of the Laws of Guyana, 1977. And that's the last green volumes that we are acquainted with. Almost 40 years after the last formal revision in 1977, the 2012 edition of the Laws of Guyana was published in 2014. The completion of this publication of laws, is the Laws of Guyana as in force as at December 31st, 2010. The completion of what is now known as the purple volumes, and that's the volumes that we now use, was financed through a loan from the Inter-American Development Bank under the Modernization of Justice Administration System project. This law revision exercise commenced under my predecessor, Senior Counsel Dudnath Singh, continued under Senior Counsel Charles Ramson, and was concluded by yours truly in 2014. Justice Claudette Singh, now chairperson of GCOM, executed this initiative. This edition is available to the public free of charge on the website of the Attorney General Chambers and on the website of many other government agencies. After publications, errors and omissions were discovered. This was understandable, since it was 4 decades of legislation that were reviewed in that exercise. As Attorney General then, I commissioned the late Justice Abdullah D. Zuru, a law revision consultant from Nigeria, to correct the deficiencies highlighted by members of the legal fraternity and stakeholders. Unfortunately, we left government in 2015 and absolutely nothing was done between 2015 to 2020. When we returned to government in 2020, I broached the issue of resuming the law revision exercise with His Excellency Dr. President Mohammed Irfan Ali and received his immediate authorization to proceed. I learned that funding for such a venture was available under the Improved Access to Justice in the Caribbean Impact Justice Project being financed by the Canadian government. I made contact with Professor Vilma Newton, who is here with us, regional director for the project, and had no difficulty in enlisting her support to the tune of $350,000 US to finance the project up to the year December 2021. Recognizing that in the year 2022, a number of important pieces of legislation were enacted, I sought His Excellency's and Cabinet permission and funding to extend the project to 31st of December 2022. The cost to do so was $100,000 US. Without hesitation, His Excellency and Cabinet granted its approval. In 2024, a decision was made to add to the project subsidiary legislation. To this end, the subsidiary legislation made under selected, revised, and consolidated laws became the subject of the law revision process. Approximately 325 pieces of subsidiary legislation were revised. Funding for this portion of the project was again provided by the government of Guyana at a cost of $130,000 US. Printing of the revised laws of Guyana was financed again by the government of Guyana at a cost of $178,640,000 and includes 200 sets of 19 volumes of the laws of Guyana. 19 of these red volumes, 200 sets each. The law revision process involved the staff of the Attorney General Chambers providing electronic files of the last revised edition of the laws of Guyana and the gazetted publications of the laws of Guyana for the period 2012 to 2022. The Law Revision Center of Anguilla provided data capture, formatting, electronic consolidation, revision, and proofreading. Law reporting. The second component of this launch is that of the Law Reports of Guyana, 2008 to 2021, containing the significant decisions emanating from cases decided by Guyana's High Court, the Court of Appeal, and the Caribbean Court of Justice for these years, 2008 to 2021. Law reporting is the process of recording and publishing judicial decisions made by courts and provides a record of these decisions, along with a summary of the relevant facts and legal principles that were considered in the case. The purpose of law reporting is to provide guidance and precedent for the future legal cases, as well as to promote consistency, predictability, and fairness in the dispensation of justice. In Guyana, the decisions of the judiciary form an important part of the law. Guyana's legal system is primarily based on the common law of England, which has the doctrine of precedent as one of its cardinal principles. This doctrine is captured in the Latin maxim, stare decisis e non quieta mover, which means standing by decisions and not disturbing settled points of law, often simply translated as let the decision stand. In the case of Attorney General of Guyana, Sarah Brong and Vikash Ramkisoon against Christopher Jones, and I see Vikash Ramkisoon here, decided by the Caribbean Court of Justice in the year 2024, the court stated, and I quote, "The principles of stare decisis, in bracket, to stand by things decided, requires courts to follow the precedents established in previous judicial decisions when ruling on similar cases. The principle promotes consistency and predictability in the law," unquote. The doctrine of precedent or stare decisis dictates that courts lower in the hierarchy are bound by the previous decisions or precedents of the courts above them when the facts of the cases are sufficiently similar. The ratio decidendi, or the reason for the decision, forms the binding precedent of a judge's decision for future judges to follow, or magistrates, as the case may be. The operation of binding precedent is reliant upon the existence of effective law reporting. Professor Rosemary Bellantoine, in her text Commonwealth Caribbean Law and Legal System, at page 126, highlights, and I quote, "Because principles of law are located in decided cases, the doctrine of precedent depends on an efficient system of recording the law for its sustainability, accessibility, and viability. Inadequate law reporting is a severe defect in the legal system, as it leads to insufficient exposition of the legal principles of the Commonwealth Caribbean law, which judges may have pronounced upon but which are not easily accessible, unquote. Apart from its usefulness from the standpoint of precedent, law reporting contributes to the development of a country's jurisprudence. Where there is no proper law reporting, where there is no proper law reporting system, a country's jurisprudence becomes stagnant. This stymies judges, legal practitioners, and law students in their academic research and other pursuits. It also stifles the growth of development of the law, which in turn negatively impacts economic and social progress in any society. Law reporting, a historical overview. The history of law reporting in Guyana follows a similar path to that of law revision and consolidation begun in the latter half of the 19th century. There was no continuous process where the law reports were regularly edited, compiled, and published. The practice of preserving the records of written decisions of judgment of the Supreme Court began in 1856. The first law reports produced were in volumes of cases decided in the Court of Review from 1856 to 1873. These were edited by local magistrates and constituted one of the earliest forms of law reporting in the English-speaking Caribbean. Since then to independence, there was sporadic but constant publication of law reports either annually or for consolidated number of years. The annual publications were published under the banner Law Reports of British Guyana. After independence, the reports became known as the Law Reports of Guyana, but to be cited as the Guyana Law Reports, GLR. No law reports were published between the years 1974 to 2007. Again, under the modernization of the Justice Administration System project, funded by the Inter-American Development Bank, an initiative was launched to resume publication of law reports of Guyana. In 2013, this exercise was completed, and as Attorney General, I was privileged to launch the law reports of Guyana from 1975 to 2007, along with an index featuring cases from 1930 to 2007. And I want to recognize the efforts of our now sitting acting chancellor, as I believe she played an extremely pivotal role in ensuring that the project then was completed. As illustrated, the process of revising and consolidating the laws and publishing cases is an enormous task. It is also an expensive exercise. In the year 2021, I again approached His Excellency President Dr. Mohamed Irfan Ali for his support and authorization to resume the publication of the law reports of Guyana. And again, without hesitation, I was instructed to proceed. In 2022, the Law Reports Project commenced. Professor Velma Newton was contracted as the consultant and editor and has worked tirelessly to complete this project. The process involved collecting and organizing judgments and decisions from the High Court, the Court of Appeal of Guyana, and the Caribbean Court of Justice from the year 2008 all the way to 2021, reviewing and summarizing these judgments and decisions and preparation of a comprehensive index. The government of Guyana funded this project in its entirety at a cost of $92,085,000, including printing of 750 sets of 14 volumes of the law reports. And we deliberately extended the project to 2021 so that we can include in the law reports all the important cases that flowed from or preceded the 2020 elections, because those are important cases not only for our jurisprudence but for the democratic history of this country. And all those judgments, and there are many, many one of them, are in these volumes. Mr. President, your name is here as a litigant several times. Law revision and consolidation and law reporting will remain a priority of our government. The goal is for the Attorney General Chambers to be fully equipped with the legal and technical capacity so that continuous law revision and law reporting can be realized. Several lawyers at the AG Chambers have received training in law revision and consolidation by the Regional Law Revision Center in Anguilla. The Law Revision Unit, of which I am the chair, will preside over this exercise. With respect to law reporting, Professor Newton has already begun to train several state counsel in the chambers in preparing cases for the next set of law reports. This exercise will continue. Before I conclude, personally and on behalf of the government of Guyana, I must extend profound gratitude to the large number of persons without whose unflinching and dedicated work these projects would not have been completed. While I cannot possibly mention the names of them all, I feel compelled to single out a few. Firstly, Professor Velma Newton, to whom both components of this project owe a debt of gratitude. She carried the bulk of the work on her shoulders. Her energy, diligence, and perseverance have been nothing short of phenomenal. I also wish to thank the staff of the drafting department of the Attorney General Chambers, including, of course, Ms. Joanne Bond, Deputy Chief Parliamentary Counsel, and the litigation staff of the Attorney General Chambers, who worked tirelessly in ensuring these projects became a reality. I must also recognize the contribution of my permanent secretary, Adele Clark, and the staff of the Guyana National Printers Limited, in particular Ms. Latoya Herbert. Ms. Yolande Dash and the staff of the Law Revision Center in Anguilla worked beyond and above the call of duty to ensure the successful completion of the laws of Guyana. Without the invaluable input of these persons, and of course many more, we would not be celebrating this launch today. I thank you very much for your attention.